A bill requiring state conservation wardens to have reasonable suspicion to go onto private lands brought out emotional testimony at the state capitol last week. Some say the wardens are trespassing, while others say they're doing the needed job of protecting fish and wildlife. According to its author, Assembly Bill 411 was propelled forward by one dramatic case that landed a Lafayette County farmer in jail.
That almost cost me my husband over 40 years. It almost cost my kids their dad.
Sue Steetz's husband Robert was looking for trespassers on his land at dusk one day in November 2012 when he encountered two men he didn't know were DNR wardens. It led to an armed standoff.
The two wardens who trespassed on his land confronted and violently accosted him. Subsequently prosecuted him.
Steetz was convicted of a felony and spent a year in jail before the Wisconsin Supreme Court overturned his conviction in June. DNR wardens often inspect private lands with no restrictions, and state law permits it. AB 411 would limit that right.
This bill will simply enforce the law of trespass against DNR unless they've got reasonable suspicion.
Opponents of the proposed legislation contend that's not constitutional.
The entry of Wisconsin conservation wardens onto the open fields of private land without reasonable suspicion or probable cause is fully consistent with the United States and Wisconsin Constitution.
And many sportsmen say that's necessary to enforce hunting, fishing, and trapping laws.
We understand that fish and wildlife are owned by the public, and there is a strong need to protect that fish and game from being poached, even on private lands.
A committee vote on that bill is yet to be scheduled. As for Robert Steetz, he is now out of jail, but the Lafayette County District Attorney does have the right to retry him.